Steven, are we okay to start?
Yep. So I'll stop share now.
Excellent. Okay, so good afternoon or good morning or good evening, depending on where in the world you're all located. So in this panel, the one that we are hosting now, Simon Berman and myself, we are going to speak with four excellent speakers about the link between climate migration and the operation of courts. As you all probably know, there is quite a lot going on, whether through climate litigation or human rights litigations, but also very importantly in domestic courts. So this is what we're going to do today. We will describe what's going on, we'll identify some of the challenges, and eventually we are also going to try to see whether we have here a topic that is more or less stuck on the international level, stuck when it comes to international negotiations, a topic that can find some developments or some movement also through the decisions of courts. Now, this panel will be more of a roundtable discussion, and I will open with a round of questions, and then Simon will follow with a second round of questions. And then we are going to take some questions from the crowd. So people listening to the discussion at home, if you have any questions, just type your questions into the Q&A box. So this is what we're going to do. But before everything, let me please start by introducing our speakers for this afternoon. So first of all, we have with us today Sumudu Atapato. Sumudu is the Director of Research Centers and International Programs at the University of Wisconsin Law School. She's also affiliated with a great number of institutions, and she has written extensively on the interaction between the environment and human rights. Our second speaker today is Scott Leakey. Scott is an extremely experienced international human rights lawyer and is also the director and founder of Displacement Solutions, which I'm sure most of you are familiar with. Scott worked in more than 80 countries, as well as with a number of United Nations agencies, and is the driving force behind more than 100 United Nations and also other normative standards, including, of course, the Peninsula Principles on Climate Displacement within states. Our third speaker is Camilla Schloss. Camilla is a judge at the Administrative Court of Berlin, where she decides mainly on asylum and immigration cases. She previously worked also with the World Bank, where she led analyses on gender and land regulatory reforms. And when she is not working as a judge, she is also publishing on displacement, disasters, and climate change. And last but not least, we have also with us Matthew Scott. Matthew is a senior researcher in human rights, disasters, and displacement, and is also the head of the People on the Move thematic area at the Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Lund, in Sweden. And he also recently published with CUP an excellent monograph titled Climate Change, Disasters, and the Refugee Convention. So these are the speakers, and I'll just quickly introduce myself and my co-moderator. So I'm Avidan Kent. I'm an associate professor at the University of East Anglia, and my co-moderator is Simon Berman, who is an associate professor at the University of Warwick. So now that we all know each other, without any further ado, I would like to start this discussion with Sumudu. And more specifically, Sumudu, I would like to ask you to frame this topic for us, at least on the international level. So the attempts to address climate change, and more specifically also climate-induced migration through international tribunals, are hardly new. We had the Inuit petition about 16 years ago. And since then, we've seen many other attempts to go to a variety of international tribunals. So again, Sumudu, can I please ask you to frame the topic for us? Tell us what these claimants are arguing, how they link human rights law to climate-induced migration, what kind of remedies are they hoping to get, what kind of challenges they're facing, and also importantly, how successful, in your view, the strategy that we're speaking about here has been so far. So,
Thank you, Avidan, and thank you, Stephen and others for organizing this event. So there are several questions in that question. So what do these claimants argue? So their main argument is that climate change and its consequences are causing or having an impact on human rights, and particularly human migration will give rise to a violation of rights, or the claimants are not in a position to enjoy their rights because of the adverse consequences associated with climate change. And as we know, these range from sea level rise to increase extreme weather events, wildfires, droughts, etc., water shortages, food shortages, etc. And in very extreme cases, people have to move from their homes. And as we can imagine, this can be a very traumatic experience. And particularly when it comes to indigenous people, they have a very intimate relationship with their land, so leaving their ancestral homes, even if it is internally, even if most migrations happen internally, that can be a very traumatic experience. So what they're arguing is that these consequences have a direct bearing on the enjoyment of rights, especially if they have to move from their home, whether it's internally or externally. I mean, external migration, of course, has a lot of other implications, including nationality. But that is the basic argument, right? So linking human rights to migration, again, as I said, all these consequences will have a bearing on the rights. And if people move across borders, then of course, you know, there are other legal questions that arise. And when it comes to small island states, a host of other legal questions will arise. And in terms of remedies, these have, again, there's a range of remedies that they're seeking. If they are moving across borders, the question is whether they can seek refugee status in another country. So some have claimed that. So that's one remedy. Another interesting remedy or, you know, a claim that they're making is that their states should reduce their greenhouse gas emissions. And because as we know, there's a direct relationship with the level of greenhouse gas emissions and the consequences. So in some cases, these claimants are asking their state or asking the judiciary to require the state to reduce their greenhouse gas emissions or increase the ambition. Right? So as we know, the commitments that states have made under their NDCs are insufficient. So increasing their ambition is another sort of remedy they're asking. So what are some of the challenges? There are legal challenges as well as political ones. And legal challenges include admissibility. The claimants have to show that local remedies have been exhausted if they're going to an international tribunal. They have to establish that there has been a violation of their rights or a violation is imminent. And in the case of climate change, they have to establish personal injury. And in the case of climate change, this might be problematic because the consequences are so widespread and pervasive that establishing damage or above and beyond what everybody else is experiencing might be problematic, might be difficult, right? And also, how imminent is imminent damage, right? This issue arose in the Tetiora case, and we can discuss that later. And a defense that states advance, and this is something that Australia, for example, said, is that climate change is a global issue, right? So you cannot really hold one state accountable for a global problem, right? And luckily, the judiciary seems to be not very sympathetic to this defense, right? And the vertical nature of human rights might be problematic too in some cases, especially if these claimants are, if there is cross-border migration involved, right? Because in the Tetiora case, was New Zealand violating a citizen of Kiribati rights, right? Because there's no real vertical relationship there. So that could be another problem. And in addition to all this, there could be political threats, right? When Vanuatu was trying to request an advisory opinion, the United States said, sorry, we are, if you guys do this, we are going to withhold your aid, right? So there could be other threats than these legal issues. How successful these strategies are, it depends on what you mean by successful, because if you think about the claims they are making, maybe they have not been very successful. But if you look at the wider picture, I think these cases have been remarkably successful, particularly the Inuit petition. If you look at it, obviously the claim was dismissed, but their objective was to bring attention to their plight, to show that climate change was already having an impact on their traditional way of life. And they also wanted to show that there was a direct link between climate change and human rights, and their rights were already being violated. So from that point of view, I think that petition was remarkably successful, and it also had a cascading effect because since then there has been so much activity in the United Nations, in human rights bodies, linking these two areas, which ultimately I think led to the inclusion of a provision of human rights in the Paris Agreement, of course, in a diluted form. Nonetheless, it's there. And another success was the Tetiora case, where the UN Human Rights Committee accepted that in extreme cases, adverse consequences relating to climate change could affect the right to life, triggering the non-refoulement principle. And I think this was huge. Although again, the petition itself was dismissed, I think this has far-reaching implications. So I think I'll stop there. We can discuss these issues later. Thank you.
And thank you very much, Samudu. So as Samudu is explaining, it seems that international law certainly have a role to play, even if there are certain limitations. The role is probably wider than just legal remedies. So building on this, I want to move on and ask Scott a question. I want to ask Scott about the potential use and the potential role of a very specific type of a law. I want to ask you, Scott, about the use of soft law. So there are currently so many soft law instruments out there, including, of course, the Peninsula Principles, which you know very well, but also other examples like the United Nations Guiding Principles on Internal Displacement, or Sendai, or the Nonsense Protection Agenda. So, Scott, my question to you is, what can we do with all this body of soft law? What can we do with it in the context of litigation? How can lawyers integrate and rely on these instruments when they're arguing before courts?
Well, thank you very much, and thank you for inviting me. Just so you know, to put it into context, I'm speaking to you from the absolutely worst climate change legal jurisdiction in the world, the state of Victoria, which is otherwise a really good state. But when it comes to climate change and CO2 emissions, we suck very badly. And that is also extrapolated at the national level as well, where all of you know that our standing globally on this question is very, very far behind where it should be. having said all that, in reference specifically to your question, it's important to put everything into a broader context when it comes to the whole question of litigation first, and then I'll turn quickly to the Peninsula Principles. So we've done a lot of work on the whole litigation question. We came out with this report at the end of last year, beginning of this year. It's called Courtrooms and Climate Change for people, in case you can't see it. So we reviewed basically every single case in the world that we knew about at that time. That had dealt at all with climate change. And at that time, there were over 1,500 cases that had made it to national courts around the world. And one of the, including, of course, the famous cases we know about that Sumudu, for instance, just mentioned, the Taitioa case, which I can comment on in great detail later if you want. That's well known. The Urgenda case in Holland is well known. The new cases in Europe are well known and will become increasingly well known, the German cases and the new Dutch case, etc. But it's important to remember, there's a million things that can be said about these things, but the overwhelming majority of these cases have not at all dealt with any human rights issues. They've dealt with emissions questions and and totally the mitigation side of the climate change equation, and very, very little with the adaptation side. And of those that have dealt with the adaptation side, which is a small minority, an even smaller minority have dealt with human rights questions at all. And an even smaller minority have dealt with the issue that we work on primarily, which is actually resolving climate displacement. So when the second round of questions comes around, I'll specifically articulate 5 or 6 areas that could and should be litigated on when it comes to housing, land, and property rights issues of climate displaced people. But that way of thinking actually, formed the foundations really for much of the work that we did in the years running up to the Peninsula Principles. And we've been working on this issue since 2006 or so. And, much of the thinking behind the Peninsula Principles came from one crucial fundamental fact, which remains universally true to this day. We weren't really sure at that time. Things have really evolved a lot in understanding, etc. Do remember too, putting everything into context again, if all the ice in the world melts, because I'm not sure how many climate change people per se are in the audience, but if all the ice in the world were to melt, sea levels would rise, not a few centimeters, not a few meters, but 68 meters. Okay, that's a real number from academic, German scientific institutes, etc. So that's what we're grappling with here. And things are not going in the good direction. So we are literally talking about a topic that is going to result in the changing of the world maps, of how maps are actually drawn. Coastlines are going to change so much that we're going to need new maps in the coming years to show how these changes have taken place. Obviously, that's going to have a massive impact on people and on displacement. The driving force behind the Peninsula Principles on climate displacement within states came from one fact primarily, and that was simply that displacement, when it comes to climate change, is not primarily going to be a cross-border phenomenon. It's primarily going to be an internal displacement question. No matter when it takes place, whether it's now, where there's displacement happening all over the place, I can name 50 countries off the top of my head where it's happening, but into the future as well. There will be people that try to cross borders, of course. There will be people who have no other choice, particularly the small island states, etc. But primarily it's an internal displacement question, so it needs to have internal displacement remedies applied. And that is really the driving force behind how we, meaning judges and lawyers and UN officials and so many other climate change experts, activists, put together the Peninsula Principles, which are really based on a conglomeration of pre-existing international human rights and other laws that are directly relevant to people who are displaced, but within a context of climate displacement, and particularly from the view of a remedy. Like, how do you actually solve climate displacement? It's one thing to say it's a problem. How do you actually resolve it? How do you get person A to place B safely and securely in a manner that doesn't violate their rights at all and that actually protects it? So first you have to proclaim that climate displaced people are a separate group of rights holders that deserve particular types of support. And the necessary policies and laws have to be in place. And you can use soft law principles to do that. the principle of new homes for lost homes and new land for lost land also has to pervade national human rights policy, national laws, national programs to make sure that people don't end up homeless or landless, which is prohibited under international standards. The third thing that we focused on was that land lies at the core of the problem, but it also lies at the core of the solution. We did this amazing calculation with all these weirdo techie types, and we figured out that if you gave a certain portion of the world's land surface to each climate displaced person or household based upon the average number of people who will be displaced, and we used 250 million at the time, the real number is probably much higher. We calculated that you only need 0.14% of the land surface of planet Earth, the 72% of Earth that's land, to actually provide a concrete piece of land to people as a place to resettle should they need to do so, which completely kills the argument that there's no land available. That's not the question anymore. It's a question of how that land is acquired and how it's accessed and the processes that lead to that first step of land. Land is the first step in a 100-step process that leads to successful relocation. And then we pushed for the whole idea of climate land banks. So that every government everywhere in the world should set aside a certain portion of land and hold it in trust for climate displaced communities when and if they need it down the road. There's no country in the world virtually that couldn't do this tomorrow. And it's a preventative measure that helps prevent landlessness and homelessness down the road and shows that your government's taken serious this question, and you need to have an official in place to look after this question. And then finally, now the issue that we're working on, so you can see the sort of evolution of the process, is the whole idea of climate displacement havens. So working with communities in a number of countries that actually want climate displaced people to come to their community, places that are losing population, places that need temporary and then permanent workers, people that want a bigger population and who are willing to focus particularly on countries that are suffering with this. So I could go on for hours, but I'll stop there.
Okay, thank you, Scott. That was really, really clear and very interesting. And now I want to move from the global perspective, if that's okay, to the more domestic or national perspective. And Camila, my next question is for you. So many of us are international law people, many of us are international lawyers, and our focus is therefore, of course, placed on international tribunals. But the reality, of course, is that most of the relevant litigation is happening, in fact, in domestic courts, and which most of us are not very much looking at or speaking about. Now, I know that you looked at more closely at the decisions of German courts, and very interestingly, you did discover that climate change, or at least environmental considerations, are in fact playing at least some sort of a role in asylum decisions and asylum applications as well. So what I would like to ask you, if that's okay, two questions actually. So the first question, please tell us a little bit about these cases, in what ways climate change or environmental degradation are affecting the decisions of German courts. And secondly, please tell us whether you believe that the importance of these factors, so climate change or environmental considerations, will in fact increase in future years, because of course climate change, as Scott just said, is going to become even much more of a noticeable problem, to say the least. So for example, will we see, what will it look like in the future? Should lawyers, for example, start practicing their knowledge of climate change science in order to improve their claims, improve the chances of success before courts?
Thank you very much. Before starting, I just want to mention that I'm talking in my personal capacity and due to my academic interest in this topic and not on behalf of the court. When I started working as a judge in the administrative court, I noticed that several attorneys pointed out to severe droughts in Afghanistan in 2018. I became curious and underwent a review of case law in the public German legal database. I noticed that indeed, applicants seeking protection had invoked environmental decisions before the court. often in addition to their persecution story. For example, a Somali applicant mentioned droughts resulting in famine, malnutrition, and increased child mortality. A Pakistani applicant mentioned floods destroying his fish farm and other plots of land. How, as you just asked me, have German courts dealt with these arguments of claimants in asylum cases? What is the legal classification? Let me briefly explain the German asylum system. In an ordinary asylum case brought before the administrative courts, there are three forms of protection: refugee status according to the Refugee Convention, subsidiary protection, which is a protection institute within the EU based on the European Qualification Directive, and thirdly, a ban on deportation, non-refoulement, based on German immigration law in conjunction with the European Convention on Human Rights. In Germany, as mostly discussed also for the rest of the world, neither refugee nor subsidiary protection is currently granted to persons displaced due to national disasters. Among others, these forms of protection require a human actor responsible for the harm in a targeted matter. This is often not the case with natural disasters. But we do not have this requirement of an actor for a ban on deportation. Let me briefly explain the German concept of a ban on deportation. I believe that Matt will talk about it a little more later. According to the German Residence Act, a foreigner may not be deported if deportation is inadmissible under the terms of the ECHR. This leads to a ban on deportation when a foreigner is threatened with inhuman or degrading treatment in her or his country of origin within the meaning of Article 3 ECHR. Unlike subsidiary protection, this ban on deportation does not require a specific human actor responsible for the harm, while the EU and German courts have stated that humanitarian conditions may result in an inhuman or degrading treatment and hence give rise to the breach of Article 3 ECHR. This is where natural disasters are taken into account by the courts. In determining a ban on deportation due to the humanitarian situation, the courts analyze the conditions in the country of origin, as well as the applicant's individual situation in a cumulative assessment. For example, the Higher Administrative Court of Baden-Württemberg mentioned in its 2020 decision concerning an Afghan national the following relevant factors for determining the humanitarian situation under Article 3 ECHR: the general economic situation, the food, housing, and healthcare situation, the volatile security situation, the recent COVID-19 situation, as well as the environmental conditions. Hence, when conducting this assessment of the humanitarian situation, a significant number of German decisions have alluded to natural disasters, as my research in the German database has shown. In some cases regarding Ethiopia, Mali, and Togo, the courts mentioned natural disasters only briefly, concluding that the overall humanitarian situation was clearly not grave enough. In several decisions regarding Afghanistan, Iraq, and Somalia, German courts analyzed the effects of natural disasters in a detailed manner. Droughts were prevalent in these countries, which led to drastic food and water shortages. However, there are heavy limits to the protections. All the decisions emphasize the restrictive application of Article 3 ECHR when the harm is caused by a humanitarian crisis of an entirely natural origin. Article 3 ECHR is only breached in very exceptional cases where the humanitarian ground against removal are compelling. Therefore, German courts seem to be hesitant to grant blanket protection for all returnees to a country. But there are examples where a ban on deportation was granted on an individual basis. In these cases, the individual's vulnerability, such as poor health conditions, was the tipping point. The recent decision by the Higher Administrative Court of Baden-Württemberg goes a step further. The overall assessment of the humanitarian situation led to a non-refoulement obligation even for a healthy male applicant with no family network. However, I must say the tipping point were not the environmental disasters, but the negative economic effect of the COVID-19 pandemic. To conclude, as shown, German courts take the environment into account when examining a ban on deputation based on immigration law in conjunction with international human rights. As for now, they take the environment into account not as a determining, but as a supporting reason. How it is going to continue depends on the facts on the ground. If, as predicted, climate change and the environmental disasters continue to occur, this will also be taken into account by the courts. It's an obligation according to the European Qualification Directive to always assess the information of the country of origin at the time of taking the decision. Thank you.
Thank you very much, Camila. Maciej, I want to move on with you, and I want to ask you essentially the exact same question that I asked Camila, but with respect to the jurisdictions that you looked at. I know that you researched jurisdictions, you researched Austria and Sweden more particularly, and I want to ask you to tell us what you discovered about these very specific jurisdictions, and also, just like I asked Camila before, where do you think that this is all going? We will see more of this in the future. Do you think that perhaps through more climate-focused court asylum decisions, and perhaps with a bit more of an evolutionary interpretation of the law, some sort of an activist interpretation of the law, perhaps eventually, if the facts will change, we will see maybe a new category of climate refugee, or am I pushing it too far?
Well, you wouldn't be the first to call for that category, Avidan, but so far the courts would say you're pushing it too far. And maybe some of the research that we've done in Sweden would caution against it as well, and I'll come to that. We have done research looking at Sweden and Austria recently. This is supported by the Austrian Climate Fund, and we've done that research together with the Ludwig Boltzmann Institute of Human Rights. They've looked at the Austrian case law, and I've looked at the Swedish case law. But I've also spent a lot of time looking at decisions from a range of other jurisdictions, Australia, New Zealand, the United Kingdom, the USA, and others. Those Anglophone jurisdictions I cover more in the Cambridge University Press book that you mentioned in the introduction. And the work on Sweden is coming out in different articles as we get the final analysis done. But this kind of litigation has been going on since the 90s even. When I looked at the Anglophone jurisdictions, I used UNHCR's RefWorld database and found, after filtering out sort of irrelevant references to disasters and climate change, about 200 cases in that database where people had made specific reference within the context of claims, or where the disaster featured in country of origin information. But even still, so out of that 200, quite a small number of those claims were individuals actually saying, I can't go home because of disasters. And that gels a lot with what Scott was saying about the vast majority of displacement being internal rather than across borders. We're not seeing huge numbers, which we often hear predicted, of climate refugees moving en masse to countries of the global north. I haven't seen that in any of the jurisdictions I've looked at. Having said that, the colleagues looking at the Austrian caseload have found far more than the cases I've found in Sweden or any of the other jurisdictions. So there's certainly cause to look more closely at other jurisdictions to see what's happening there, because it is early indications that at least this reality of people seeking international protection has come to pass. And then looking at different jurisdictions shows us how very differently courts deal with these kinds of cases. And that's problematic in a number of ways. Some jurisdictions look very closely at the Refugee Convention and then go on to consider complementary protection, as well as potentially even domestic provisions relating to immigration law, compassionate circumstances, and so on. Others go straight to domestic bespoke provisions, like we have in Sweden, one of the few countries that has a environmental disaster category of international protection. And when that happens, we don't see that kind of progressive development of international law. And in fact, we don't see much development of anything, and I'll mention that before I close. But when we see judges dealing with claims for refugee status, we see the problems that exist on the wider level of the Refugee Convention's interpretation, that there are different ways of interpreting it. And in some cases, climate refugees can get protection, particularly when there's a connection to the intentional infliction of harm for a convention reason. So there's a very often cited case from the New Zealand Immigration and Protection Tribunal about a person from Myanmar who was involved in the humanitarian relief in the aftermath of Cyclone Nargis in 2008, and as a consequence was pursued by the authorities as a person with an imputed political opinion. She got refugee status, but there the disaster was the backdrop. When it's foregrounded, it's much harder. There's some recognition, for instance, in an upper tribunal case from the United Kingdom, where discriminatory denial of disaster relief can support claims for refugee protection. And then the harder category, which is where we find a lot of people potentially captured, is where disasters engender differential exposure to disaster-related harm. And this sort of structural violence is not well captured, even though some of the considerations in the New Zealand Tribunal, again, adopting a human rights-based approach, the case of AF Kiribati, which became Te Tiota against New Zealand, did reflect a much more nuanced human rights-based consideration, which understands the kind of structural underpinnings. So the Refugee Convention has some potential, but it's very, very limited scope, and I don't see that expanding substantially. Human rights, complementary protection provisions, Te Tiota is the best example, but that again started in a domestic jurisdiction in New Zealand. And finally, with these bespoke provisions like we have in Sweden, the result of our research was quite disappointing. And it suggests that there are some potential unexpected pitfalls of designing new categories to capture climate refugees, because what we saw in Sweden was a tendency towards very narrow interpretation of the provision that resulted in standards that were almost more difficult to meet than those under existing provisions of refugee status or complementary protection. And then there's more to look at in terms of humanitarian provisions under immigration law and so on, but cautioning against a category for climate refugees, definitely advocating for more litigation to flesh out what the scope is of international law, but also encouraging us to look at domestic provisions, as we've heard from a recent article from David Cantor. Pausing.
So a lot of wishful thinking on behalf of the moderator and less achievements on the ground. So Simon, to you.
Yes. Hi, everyone. So yeah, I'm going to be taking over. I have a few questions of my own to ask various members of the panel. I'm going to sort of go in reverse order. And so to stick with you, Matthew, just for the moment. You mentioned, you talk about the Te Tiota case, other people have mentioned it as well. And perhaps if we can take anything from the Refugee Convention, perhaps it's the principle of non-refoulement. But of course, non-refoulement, insofar as it has a relevance here, is the way in which it's broken free from the convention, specifically to become arguably a part of customary international law in terms of its relationship to human rights. And certainly we saw that in Te Tiota. But I wanted maybe specifically to talk about the European Convention on Human Rights, which arguably, the European Court of Human Rights is where the link between non-refoulement and human rights arguably started with the Söring case back in the late 80s and so on. And I just wondered, do you think there is potential scope for the principle of non-refoulement to be applied within that context with the European Court of Human Rights? And to what extent do you think that's a potential avenue in this jurisdiction?
Yeah, thanks, Simon. I spent time back in 2014 writing about the possibility of individuals resisting removal with reference to Article 3 of the European Convention, as well as with reference to Article 8. Article 3 relates to the prohibition on torture and is basically the non-refoulement provision as it's come to be interpreted, as you mentioned in Suring and then subsequent cases. And Article 8 relates to private and family life, and that's also been relied upon to resist removal, even if it doesn't quite accurately be characterized as non-refoulement. It's still really important. I think since Tetiota, the prospects of further litigation to the European Court of Human Rights have expanded a bit. I don't know if the prospects of success are much greater, but there's something to be seen there in terms of encouraging domestic lawyers and to take the principles that we see in Tetiota into the courtroom in domestic jurisdictions and try to make them stick, maybe with better fact patterns than we saw in Tetiota. I mean, the threshold will always be high, but we see a broadening from Tetiota that encourages courts to consider denials of economic and social rights in a way that they might not have done previously. And that was within the context of the right to life. So there's prospects there, but the prospects have been there for a while. And when I wrote in the IJRL article in 2014, I pointed out the Sufi and Elmi case, which was a case where individuals successfully avoided return to Somalia in the context of the famine in 2011, relying on Article 3, and the court there developed a different test than what's been applied previously, where you might have thought of the N against the UK test, which has an exceptionality threshold. In the Somali context and the famine there, the emphasis was on the inability of the claimants to satisfy basic needs to water and shelter, but also emphasized the security situation. And I haven't seen cases since Sufi and Elmi, apart from one unsuccessful case called SHH against, I think, again, the United Kingdom. And that was a case where Sufi and Elmi wasn't followed intentionally. The court distinguished there, really placing an emphasis on the conflict and the role of the actors of the parties to the conflict. So if we see confluence of conflict and disasters, that kind of paradigm can work at the European Court. And with a bit more emphasis on Tetiota, we might expand that beyond a conflict setting to other settings. But I haven't seen a lot of it. When it comes to Article 8, I think there's a lot that can be said because there have been developments since 2014. I just noticed a case in the European Court of, in the UK Court of Appeal, where a person successfully secured a right to remain in the UK on the basis that her husband, who was a British citizen, if I remember, was unable to tolerate the high levels of heat in India, and taking all of these other factors into consideration, the relationship with a British partner, the length of stay in the country, plus the adverse environmental conditions in India, this supported a claim to stay. And so what I expect is we might see the integration of environmental considerations in other kinds of claims, whether for international protection or under other provisions, which include Article 8, but can also include domestic provisions. And I'll close on that point with reference to the recent decision of the French Administrative Court of Appeal relating to a Bangladeshi person who successfully avoided being returned to Bangladesh because on return he risked potentially dying as a consequence of asthmatic attacks. because of the poor air quality. So we're seeing environmental conditions influencing decisions about non-citizens and their ability to stay in host countries. And I think the more climate emergency becomes an evident fact of everyday life, the more we're going to see those kind of claims. And the role for lawyers and judges is to have, in relation to kind of the question Avidan asked Camilla, to have that climate understanding, not to become physicists or climatologists, but to understand what's going on in relation to disasters and climate change, so that that kind of relevant country of origin information can be integrated. And hopefully those kind of cases will make their way up to the European Court and influence it. We also need that transjudicial dialogue that Hathaway has talked about a lot, so we don't end up with this kind of smattering of different approaches. And decisions from the European Court, provided they're progressive and based on an accurate interpretation of international law, could help that. Thanks.
Great. No, thank you very much for that, Matthew. It's sort of just picking up from that point, and coming back to you again, Camilla. This question about causation, or what we're talking about here when we're talking about, I mean, I know the phrases of climate refugees, environmental refugees, migration, displacement, all the various terms are used. And I just was struck by, Camilla, that you kept referring to natural disasters in how they're discussed in the German courts. And I wonder, to what extent do you think that this question of causation that we often talk about, how can we distinguish between, natural disasters that are part of, Earth systems, just normal weather patterns of hurricanes or flooding, and so on and so forth, and then to distinguish that, if necessary, from specific causation caused by the effects of climate change, and then when that's layered onto issues about social, economic inequalities, and so on and so forth. I just wonder, I mean, this is something we talk about a lot in academic writing and in discussions like this, but as a practicing jurist, and in your experience in the court, is this something that matters? Is this something that's, that needs to be addressed? Or do you feel that it's something that's not really necessary in terms of engaging the kind of rights and protections that you were discussing before?
Thank you. I think it depends very much on what kind of protection we look at. I would say that causality, especially between, let's say, climate change and migration per se, is not a legal requirement within the assessment of protection. Before, in the old German asylum law, based on Article 16 of the German Constitution, there was actually the requirement that there is a causal link between the persecution and the migration. So the person had to migrate because of the persecution or the serious harm that he or she encountered in his country of origin. This was also defined by the Constitutional Court in several decisions. This has changed, however, with the new European refugee law based on the qualification directive, which I have mentioned, which overlaps or makes additions to prior refugee law in Germany and also other European countries. Here, the primary question is whether the person has a well-founded fear of being persecuted or a real risk of suffering serious harm if we turn to the country of origin. So it is not so much about why the person migrated in the past, but what will happen to the person in the future. The past does play a role when assessing the future damages. According to Article 4, Section 4, the fact that an applicant has already been subject to persecution or serious harm is a serious indication of the applicant's well-founded fear of persecution or real risk of suffering serious harm. But the assessment is rather based on the future, what will happen when he or she would return. This is especially vivid when one also takes into account that a person can also give as grounds of protection a reason that reasons that have happened after the person left the country of origin, so new reasons. So I believe that this argument of multi-causality is not so much relevant as a causal argument per se, but it's more a question of the factual assessment of the well-founded fear of being persecuted or the real risk of suffering serious harm. So the question is more, how severe are the impacts of climate factors? Do they hit the thresholds that refugee protection and subsidiary protection require? And this is also a bit the same idea of the Tetiota case and what Sununu said about imminence. So it's more the question of the factual side than a legal argument that we need one cause or can we take other causes into account. The next question is, what do we do when, let's say, climate change does not hit yet the threshold of serious harm, and we have other causes that, other reasons why the person can't return to the country. As for now, in an asylum case, each ground for protection is, I would say, assessed individually. So often in a case, for example, a person would say, I fear persecution because of, let's say, Hezbollah or the Taliban or some other non-state party. Second, I fear persecution or serious harm because of land fights that I had with my neighbors. Third, there's a family conflict going on because I married someone who my family members don't like. Each of these grounds you would look at by singly and not do an accumulative assessment. So in the end, yeah, the real factor is, does the natural hazard or the natural disaster lead by itself to the serious harm? Exactly. Yeah, I think that's the big exception is what I mentioned already before. Under Article 3 ECHR, you can do this cumulative effect assessment because you look at the humanitarian situation and you can take every aspect that leads to a negative effect on the humanitarian assessment into account.
Well, thank you very much for that, Camilla. And I guess in a way, where you just ended there, I mean, potentially, and going back to the question I was asking Matthew about the potential expansiveness of Article 3 in particular, that may offer some real potential. I want to come back now to Scott. And Scott, you, towards the end of what you were saying before, you talked about access to land and the potential that exists to accommodate people displaced with on available land. But of course, accommodating people on land, just in a sort of basic sense, doesn't deal with specific rights. So specific rights of what rights people have when they're housed on those lands. I mean, and the kind of housing that they're going to have, the kind of life that they're going to be able to lead, whether it's slum housing or proper sanitation and access to other resources, electricity supplies, all those sorts of things. And so I just wonder maybe if you could say something a bit more specific then, going into the sort of human rights aspect of property rights and housing rights in that kind of context.
Yeah, sure. I'm just looking at the clock. Lockdown is ending in 3 minutes. 3 minutes. You're going to see a transformation of one human from unfree to free just during my intervention. It's going to be amazing. Well, thank you for that question. And thank you for all of your responses. I mean, it's so nice always to hear people talk about international law as if it's a real thing, because that doesn't happen very much in Australia. Let me tell you, we could talk about that side of the equation for years. We also don't have a Bill of Rights, so you can imagine what it's like. So the question of land, the question of land is, of course, fundamental to. So you're all talking primarily about the questions of migration, questions of refugee law, questions of non-refoulement, etc. I approach this matter you know, I teach about it at law schools and stuff, and I write books about it, but from a activist perspective, I approach it from a housing, land, and property rights perspective. So what's going to happen to people who are displaced because of climate change causes in places across the world, who choose not to cross a border, but who want to stay within their own country, which is, in my experience, having worked in, you know, every region and on the ground in places like Kiribati and Tuvalu and the Solomon Islands and all these other places, Bangladesh a million times, Myanmar, etc., is that the vast majority don't want to leave. So they're going to stay. So where do they actually go? And what are the remedies available to them? Are there institutional places? You know, the very first question we always ask is, you know, for Johnny Jones, who is going to be displaced, whose door does he or she knock on? Right? And most governments can't even answer that question, let alone the subsequent questions. We tried, for instance, to negotiate the very first ever very large scale land solution for the Carteret Islanders, which have not been mentioned yet tonight. He's free, he's free, he's free. The Carteret Islands are kind of the first, they were like the Canary in the coal mine poster child of a place where you had to have mass displacement from an atoll group in Papua New Guinea to a larger island that was much safer, Bougainville, where I happened to work a lot too, helping to end the war and stuff there in the 80s and 90s. So we got a landowner to agree to sell 7,500 acres of land to the government on the condition that it would be used to resettle the islanders. So it was a win-win-win situation for everybody. This is way back in 2007 and everything. And just to give you one very concrete example, so the landowner agreed, the islanders were happy to move because they knew they couldn't stay on the atoll any longer. And the local government of Bougainville agreed. So we brought them all together in Canberra, the capital here. They all agreed. Money was allocated, and lo and behold, the money went missing. The deal fell apart, and my friend Mike, who had the land, had to sell it to an Australian guy for 400,000 Australian dollars. Can you imagine? 7,500 acres, 3,000 hectares of land, had 7 rivers running through it, 8 beaches, the whole thing, 5,000 acres of cocoa plantation, the whole thing. Anyway, if they don't have a place to go to, those islanders, where are they going to go? And that's the kind of premise that we work on all across the world. And yet, we can name some good cases where this has happened without the use of courtrooms, like the movement of the Gunayala indigenous group in Panama, who live on man-made islands in the Caribbean, who are moving to land on the mainland, which actually is under their ownership and control. They're the most autonomous of all indigenous groups in all of the Americas. They have more power vis-a-vis the national state than any other. So they have their own land essentially to go to from the man-made islands that are going underwater to the mainland. But even there, that's a kind of ideal scenario. Even there, they're facing all sorts of problems, But the default option for most people, and again, we're talking about the vast majority of people here who are going to be displaced by climate change. The vast majority of people have no other option than the slum. And the slum is already in most of these places pretty full and pretty bad. And I know them intimately, and that's not an option you want to tell people to choose, like, sorry, Mr. from Chittagong, you're going to have to go to the slum. Sorry, Mr. From Dhaka, from, the outskirts of Dhaka, you got to go to Dhaka and live in the slum. There are other options available, and if we're approaching this matter from a human rights perspective, it is incumbent on governments everywhere who take housing, land, and property rights seriously to have the institutional mechanisms in place, the remedial mechanisms, the budgetary requirements, and the land itself available so that they can actually guide this process and ensure that nobody ends up homeless or landless as a result of this. If nothing's done systematically to address this, the problems that we're talking about here, the odd case here and there of somebody trying to go back, not to go back to Ethiopia or Somalia, will just pale in comparison to the incredible social chaos that's going to occur in places where you just have more and more people fighting over less and less resources. So our approach is, you can prevent some of this by taking a proactive approach. And, I'll give you a couple of other examples. I'll give you a local example. Here in the state of Victoria, there is a town called Seaspray, which is along the southern coast on the ocean side, not that far from here, where planning permission was given to developers to develop this beautiful piece of coastal property. They got planning permission. They sold this land for quite a hefty price to about 100 different investors and potential buyers. And then they reneged on the deal 5 or 10 years later for fear of lawsuits that they would be held liable for negligence and allowing planning permission to proceed in an area that was guaranteed to become flooded and unusable. So all the investors would have lost everything. So that's just like one concrete example of exactly the type of thing that's going to happen more and more in countries across the world. And we need to have questions answered that are relevant to cases like that. So, which are not that, you can argue theoretically in law, they're clear, but in terms of the case law and jurisprudence, whether nationally, regionally, or internationally, they're not fundamentally that clear. At what point does compensation become viable when relocation is not viable, for instance? What are the precise institutional duties that a government must have in place? That can be checked judicially when it comes to protecting the rights of climate displaced people. What are the duties to provide or set aside land? And the list is really long, and the answers are really not that clear. I'll give you another example from the little village that I live in. We live on the beach, and there's all these beach boxes, like in England, those kind of little beach boxes, but they're much nicer here than the English ones. It's actually warm sometimes, and the part of our beach we're really well protected by a headland, so it's not eroding away, but the other part is completely eroding away. And you can see all the foundations of these beach boxes, which sell for $300,000 each. And they're only like 8 square meters, and you can't electrify them. You can't have water to them. You're not allowed to legally sleep in them. And they cost 300,000 Aussie dollars each. And then so the local government had a choice. Are we going to protect that beach and thus the investments of all these people? Or are we just going to let it revert to the natural sea level and just let them sort of fade away and pay no compensation? And this is an ongoing debate now. That type of thing also is just going to come up more and more. Even just in little old Australia with only 25 million people, even the conservative government has calculated that the total property losses on the periphery of Australia, our very long coastline, is over 300 billion Australian dollars in current terms. Now, that's not chump change, as we say. That's a lot of money. And the question is, at what point does the government then have to intervene to protect the suckers, the ones that think they're getting a good deal? Because this is what's happening all across Australia now. The smart guys who know about climate change are selling their properties now to people who think they're getting a good deal. I got my coastal home for only 960,000. I would have had to pay 2.4 million last year, not realizing that there's no way they can give it to their children as an inheritance because it's going to be underwater in 10 or 20 years, So, I mean, those are just a few, once again, I've gone for hours, but those are just a few of the, some of the legal issues and the rights versus obligations side that, we think really need to be addressed much more in the domestic courtrooms of the world. And I should make a plug for another thing that we do because no one else is doing it. So we thought, let's do it. And that is, I think it's the only one. Maybe there's more. Hopefully there are. We have this little program called One House, One Family at a Time. And the perspective of this is people who are displaced by climate change need somewhere to go. So let the people who have some resources, namely, donors, but mostly ordinary people like us, put money on the table and build houses for them and give them away for free in Bangladesh. And that's what we do. So we've raised enough money to build 9 houses. So there's about 50, 60 people that are living in houses now for free for the rest of their life. We're on stage 3 now. We just launched it the other day. It's going to be 11 new houses. So we'll have 20 new houses by the end of the year. And obviously, I wish it was 20 million houses. But it's to make the point, that somebody somewhere needs to start doing something concretely for these people, or else we're going to really have, that Hobbesian war of all against all will come a lot sooner than we want.
Thanks very much, Scott. I appreciate that. But I know that I'm sure there's some people here who want to ask their own questions, and we will come to other questions. But I just want to come back to Sumedh, who started us off in this discussion with just one final question from those of us who are organising this, which is you began, Sumedh, this whole discussion, I think, referring to the Inuit petition, which must be 14, 15 years ago now, and you made an argument that although it was dismissed even without a hearing, it opened the door to further developments. And you and other members of the panel have referenced the Teshioto case in the Human Rights Committee, which again, people have said, well, it helped develop the law potentially around the question of non-refoulement in the context of climate change. But of course, that too was, as you and others have pointed out, was denied, that the claim was denied to Teshioto. So really, the question I have really is, we're talking a lot about human rights, we're talking about international law, but maybe there's something fundamentally missing or problematic in sort of international human rights, how it's conceived, how it's structured, that may make it very difficult to succeed. I mean, rather than just sort of pushing forward principles, but actually succeeding in guaranteeing remedies for people displaced by climate change. So what is your view on that? Do you think that there is something fundamentally problematic with international human rights law and dealing with this question? Or are there ways in which it could be developed, or the gaps could be filled within human rights? Sumedh.
Helps to unmute, right? To answer that question, we need to see what the legal gap is, right? We have been talking a lot about the legal gap, and the basic issue is, as many of the other speakers referred to, the Geneva Convention on Refugees, which was adopted after the Second World War, does not refer to climate refugees, obviously, right? And climate change is not a condition that will allow you to claim refugee status. There are some signs, at least at the national level, where courts are saying that, climate change could be a factor, as, many of the other speakers pointed out. But the basic sort of premise is that, if you are affected by climate change, you don't come within, if that is the only reason why you're moving, there may be other factors, obviously, right? If that is the only reason you're moving, you cannot claim refugee status under the Geneva Convention, under present law, right? So that is the legal gap. And we know that, people will be moving, people are already moving. So what do we do, right? Legally, they are not protected under refugee law if they are seeking refugee status in another country. And obviously, many countries, I should say almost all countries, don't recognize this category of refugees as refugees, right? So we have a gap there. So what has happened is the human rights framework has tried to step in a little bit. Human rights law is based on the dignity of the human being, regardless of nationality, in theory at least, right? So if you are in another country, in theory, you're entitled to basic levels of protection, right? You may not enjoy all the rights that citizens or permanent residents have, but, like your right to life should not be violated and things like that. But we know that the reality is very different, right? You cannot go to another country and say, I'm, applying for refugee status. There's no, although human rights law recognizes the right to seek asylum, there's no duty on states to actually accord it, right? It's at the discretion of states. It's part of their sovereign prerogative. So that's one of the main problems we are dealing with. And also this issue, I mentioned this earlier, the vertical nature of human rights, right? Usually you claim against your own state under human rights law. You have to establish that your own state has violated your rights, right? Whatever the rights that we are claiming to be violated. Usually, human rights law does not operate diagonally. The Inuit petition was a tax case in that case, but we don't have a decision on that. But the Inter-American Court on Human Rights in the advisory opinion said if pollution can travel across borders, so can responsibility. And that's something I think lawyers should seize upon and bring several cases to test that, because obviously under international environmental law, principle 21 clearly says you should not cause damage to the environment of other states, right? So we do have that obligation under international environmental law. Why not extend that to human rights, right? If you are violating rights of other citizens in another country by pollution, then you should be held accountable. But we don't have that framework in place, right? So I'm digressing a little bit. So human rights law has tapped in a little bit, as we saw in the Tetiora case, to fill this gap to some extent. It opened the door a little bit. And again, this is something as lawyers we should be seizing upon. So the non-refoulement principle was extended to cover climate refugees for the first time, right? And recognize that climate change could, in extreme situations, have an impact on right to life, which could trigger the application of the non-refoulement principle. But that's great, but the problem was the threshold that was established by the Human Rights Committee was really high, right? It recognized that in 10 to 15 years' time, Kiribati could become uninhabitable, right? And by implication, many other small island states, right? So, but the committee felt that right now there was no imminent danger to Mr. Tetiora and his family, right? So what does that mean? He should wait until there is, like, his right to life is actually violated or about to be violated. Does he wait 5 years, 10 years, or 15 years, right? If he lives that long. So that imminent danger was a problem, right? We don't really know what the committee meant by that. And the other one was personal injury, right? I mentioned this before. The committee felt that he did not establish personal injury above and beyond what everybody else is experiencing. And with climate change, this is really problematic, right? Because it's so widespread and pervasive. The other interesting sort of issue that the committee brought up was the fact that Kiribati was actually actively engaged in adaptation measures, which kind of went against the claimant, right? Of course, if Kiribati was not engaged in adaptation measures, that itself would have been a violation of his rights, right? So it's like being in against the deep sea and a hard rock or whatever that saying is. You can't really win, right? If your state is doing good things, then you may not claim. But even if your state is doing good things to adapt, in 10, 15 years' time, it might become uninhabitable. So we don't really have answers. It opened the door a little bit, which I think is great. And I think for the first time, climate refugees as a category, as a legal category, was recognized by a human rights body. But the threshold that was established, I think, was way too high. So I'll stop there.
Thank you very much, Sumit. I think that was really coming to the very sharp questions or issues that still remain, I think, in this field. So I think we've obviously spent a lot of time discussing these issues, and I think they've been all excellent contributions. So thank you very much all to the panelists. But I'm sure that there are people who would like to ask questions of the various panelists. I think there are already a couple of questions in the chat. Bersha, are you going to be coordinating this bit?
Yes, I can, if you'd like, Simon. Yeah.
Yes, thank you.
So yeah, as Simon said, if you have some questions, please put them in the Q&A box, and we can. I think we have 15 minutes. Is that right, Simon? Yeah, about 15 minutes. Also, to the panelists, if depending on the number of questions we get, because it's been mostly asking you guys questions, if you have questions for each other, now would also be a good chance to have a bit more of a dialogue. We'll start with, we have a couple of questions from Jeff Gilbert, so Professor Jeff Gilbert from my colleague at the University of Essex. I think part of the first question has already been answered, but I'll ask it again. So it's a question for Camilla and Matthew. Have there been instances in refugee law decisions where climate change has caused conflict, for example, access to water or land, and that has generated refugee status? So he was thinking here about movements across Somalia and Ethiopia, where they've shown mixed reasons for this, as well as Jeff states that there is also November 2020 UNHCR guidance on disaster displacement. And I'll group that with the second question for Jeff, and this is open to everyone, of course. Given that most displaced persons were, whether as a result of persecution or conflict or due to disaster or some climate event, are in low or middle income countries, why is the focus on individual protection, I guess in our discussion, has been on individualized protection before courts in the global north, given so much of this cross-border is happening in developing countries? So I will go first, I guess, to Camilla and then Matthew, and then open it up to everyone else.
Thank you. I'll start with the first question. I think I've partly answered it already before. In a situation like that, I think a court would mostly look at primarily what the cause of why the person that fears to go back, and that would be as a number one reason the violence and the conflict that is in the country. Exactly. And actually, there is an extra protection under the subsidiary protection when there is a serious threat to a civilian's life by reason of indiscriminate violence in situations of international or national armed conflict. And for a very long time, what countries used to do is do a quantitative assessment, look at how many people have died in the region and ratioed it to the people actually living in the country and looking if this is a serious threat in an armed conflict. And the European Court of Justice said in its sliding scale decision, it's the El Ghafaji decision, that one also has to look at individual requirements, such as individual circumstances, which can be, for example, part of a vulnerable group. And here, being part of a vulnerable group could be, for example, an unaccompanied minor, a single woman. So maybe in this sense, one could also look at how natural disasters make certain persons who are threatened by an armed conflict especially vulnerable. A second aspect where the national disasters can play an account in subsidiary protection is when you look at internal protection alternatives. This is also a requirement for protection, that there is no internal protection possibility. And let's say there's an armed conflict going on in one part of the region. The court would look, is there another part of the country where the person could have protection? And looking at that part of the country, the internal protection area, we also take into account the humanitarian situation, then also being able to take into account the national disasters. Let's say in the other part of the country, the humanitarian situation is so bad due to the droughts, we would say that then there's no internal protection possible. Okay.
Matthew, did you want to add anything?
Yes, thanks. I'll go to Jeff's second question. It's worth highlighting the UNHCR's legal considerations that came out at the end of last year, because they represent a significant step towards better articulation of how the Refugee Convention applies in situations of climate change and disaster-related displacement. But of course, it could have gone further. It's significant in its recognition of the social factors underpinning disaster displacement, instead of framing disasters as the indiscriminate acts of nature, which has been done for quite some time, both from judges and from legal academics and others commenting on the phenomenon. UNHCR here clearly emphasizes the social factors underpinning differential exposure and vulnerability to disaster-related harm, so it should be commended. But there's a lot of space, and this is how I get to your second question, there's a lot of space for developing international refugee law doctrine because it remains unclear. And so the question was a bit, why focus on the small number of people who come to the global north? Partly because of the principle of anxious scrutiny and the need for systematic and accurate interpretation and application of international refugee law or international human rights law in a context where there are people who are actually saying, I can't go back home, and they're presenting in small numbers in countries of the global north. So there's room and there's a need to develop that more accurate interpretation and better application of international law in this context. But, and building on a lot of what Scott has been talking about, the vast majority of protection issues are in countries of the global south, like you also say, Jeff. And at the same time, I think probably it's right to say the vast majority of focus is there as well, even if us on this panel are talking about tribunals and can they save the day. Probably not, but a lot of the work is in terms of like what the UN high-level panel on internal displacement is doing, trying to bring together different actors from a sort of multi-stakeholder perspective, hearing from internally displaced people, thinking how to leverage finance, thinking how to leverage political will, and also work of actors like UNDP, the Internal Displacement Monitoring Center, not least the platform on disaster displacement, and the work of regional bodies like the Intergovernmental Agency on Development, the IGAD region in Africa, which recently developed a free movement protocol, which has Article 16 dealing specifically with cross-border displacement in that context. There's a lot of movement in Latin America as well in terms of developing these legal mechanisms for facilitating cross-border movement. And that's part of that political will in a cross-border displacement context that we absolutely do not see in countries of the global north. And that's why we kind of look to the tribunals and think, can we try and squeeze a few people through this very, very narrow door? But there's a very different kind of dynamic happening in other parts of the world. And there's a lot of actors who are focusing a lot of attention there where it's appropriate. But as an international lawyer, I think there's also space for thinking about how these instruments are best and most accurately interpreted. And certainly they won't stretch to cover the majority of people who are adversely affected by climate change and disasters. It will never save the day, but it should be applied accurately, and then we can see where the gaps are and deal with those in possibly different ways.
Does anyone else want to respond to that question? Otherwise, we can move to the next question. Nope. Okay. There's another question that's come in from an anonymous attendee. Should an international accord addressing, so about climate refugees, addressing climate change include mitigation or reparations fund? I think they mean migration or reparation fund. And if so, how would that work? So another possibly new international accord. I think Sumudu, you indicated that you would want to answer that one.
I actually sent a reply saying hopefully the loss and damage mechanism will take care of that. But we don't really know how the loss and damage mechanism will play out, particularly in light of the inclusion that the loss and damage mechanism does not lead to liability and compensation. Whether it excludes liability and compensation in a legal sense altogether is questionable. Some have said, because this was not included in the Paris Agreement itself, but in a decision taken at the Paris during the Paris conference, it's not technically binding. But there was the political compromise that states made, particularly at the insistence of the United States, in order to include the loss and damage mechanism and climate migration in the, loss and damage itself in the Paris Agreement as another arm of climate action. But the task force on climate migration was included in the decision. So we don't really know, but we are hoping that the loss and damage mechanism will take care of that. So I don't know whether others have anything to add to that.
Okay. Does anyone else have any questions, either in the audience or maybe someone else in some of our other panelists for?
Yeah, I will just add
sorry.
Go ahead, Sumudu, please.
I do have a question for Scott. I totally agree that we need to plan systematically for climate migration. We have known since the very first report of the IPCC that climate migration is going to be one of the biggest issues. And it took us, I don't know how many years to even get the negotiators to include climate migration in the climate documents, right? And took even more years to get a task force established on this. But it's moving very slowly. We know that things move very slowly at the international level anyway. But I mean, planning for this eventuality, I think, is the way to do it. But, we know that in many of the countries of the global south, they don't have the resources. They are dealing with many other pressing issues that are much more tangible right now. Basic things like food, water, electricity, right? So, and we also know that, they argue that it's really unfair for them to address a situation that was caused by the global north, right? So the legal framework has tried to address this by adopting the common but differentiated responsibility principle, but the main burden, the disproportionate burden of this entire thing is on the global south and impoverished communities. So how do we address this justice issue and get the global north to shoulder some of this responsibility when it comes to climate refugees, whether it's internal migration, as we know, will be the biggest movement, or cross-border? Thank you.
Revolution. It's the only solution. It's the only solution. Well, the thing is, there's many ways to approach that very good question. And, first of all, we sadly, we cannot make a presumption that every country of the global south is a reasonable regime, that every government is reasonable towards its people, for they're not. They're not necessarily worse than the rich West, or necessarily better, but none of them are universally perfect, right? I think we have to apply both principle and, realpolitik at the same time when it comes to these questions. And certainly our approach would be one that presumes that no one is going to come to your aid. I mean, let's hope they do in all sorts of different ways, like you mentioned, loss and damage mechanism, etc. But in all likelihood, no one is going to come to Kiribati's aid. And by the way, thanks to all of you for saying Kiribati correctly. You have no idea how rarely that occurs in an international meeting. Oh my God, the poor Kiribatis, but no one's going to come to the aid of Kiribati, let alone the new, very different conservative president of that country, who's completely the opposite of his predecessor, who actually bought land in Fiji, for $10 million. Story we broke years ago, on the second largest island in Fiji. So, they're trying to solve the problem themselves. At least Anote Tong was, the previous president, saying, we have to be ready. We're going to buy thousands of acres of land, in Vanuatu and Fiji. So at least some of our people have a place to fall back onto, and the same applies not just to the small island states, but to the bigger ones like Bangladesh too. So, everyone looks at Bangladesh, and I've been in Bangladesh many times. I know it very well. Everyone thinks, oh, there's no way they could solve climate displacement. They got 172 million people. It's a teeny place. You could fit 2 Bangladeshs into little old Victoria, where I live, for instance, so we have 5 million people. If we had the same density as Bangladesh, we'd have 340 million people, so you can imagine that the challenges facing Bangladesh are huge, and they are. To anyone who's been there, you know what I'm talking about. At the same time, we work with local groups there, and we identified 10 years ago, 10 very viable, relatively large land parcels that easily could be annexed by the state tomorrow. It's state land anyway, that could be allocated down the road to climate displaced people, So even in a country as low-lying and as poor and challenged as Bangladesh, there are local options available. What's missing is the political will to do it. And I think, I could give you 101 examples, even in Solomon Islands, population of 500,000, next door neighbor to Australia, no one ever talks about it. They have the world's biggest atoll in the Solomon Islands called Ontong Java. And we sent a guy there. There's no planes that go there. There's no boats that go there. There's no way to get there unless you somehow hitch a ride. And they're living at subsistence level, 3,000 people, total tropical paradise. They use shell money still. No cash economy. They have to move. So the government of the Solomons said, at least they said something. They said, you can have land over on Maleta, which is another bigger island, safer, higher mountainous island. And then they said, we don't want to go to Maleta. They're Melanesians, and we're Polynesians. You can't just make us go to a Melanesian area. And plus they're beach dwellers, and they were going to have to live in the mountains and the jungle. And, just those kind of considerations, they're sort of ubiquitous all around the world in different ways, But the bottom line is no one's coming to their aid. It's got to be done primarily domestically, and some help will come from overseas and things like that. But we need to get a mind frame in place within the human rights community, the climate change community, the developing world community, world of the South, that most solutions in most places are going to be domestic, and the people want them to be domestic. You flip that on its head and you say, what about slums, man? When I started working on, by the way, I'm an Essex graduate. This is what happens to you if you go 35 years after graduating from Essex LLM program. You look like me. Yeah, so you have nothing to look forward to. So, oh God, I lost my train of thought there. What was I talking about? What country? Solomon Islands? Ontong Java. No, I was going off in some other tangent. Okay, anyway.
Bangladesh.
Pardon? What was it?
Bangladesh, and them doing it themselves.
let me just change tack because I can't remember what my train of thought was on that. But basically, the bottom line is people and individual countries are going to have to do it themselves at the moment until we finally, merge ourselves together into a global civilization that we should have done long ago based on world citizenship, which is really my main thing I work on these days. But anyway, let me just say a couple of words on the Taitioa case. Because
I might just wrap up there because we have our next panel starting very shortly. Sorry, Scott, we are a few minutes over time already. Simon or Avidan, I'll give you the last word to wrap it up.
Yeah, sorry, sorry, Scott, that we had to cut you off there because it sounded like even more fascinating stuff we were going to. But really, just to say thank you very, very much to all of our panelists, to Sumadhu, to Camilla, to Matthew, and to Scott for really, really excellent discussion. Thank you very much for that. Thank you very much to Stephen and your colleagues at Essex, particularly Bersha, and to Sophie for helping, for inviting us to organise this panel and supporting us and presenting it. So just really thank you very much all of you for taking part, and we hope you found it a useful and interesting set of discussions. Take this question forward. Okay, thank you. Bye-bye.
Thank you very much.